The international community considers the establishment of Israeli settlements in the Israeli-occupied territories illegal under international law. However, Israel maintains that they are consistent with international law because it does not agree that the Fourth Geneva Convention applies to the territories occupied in the 1967 Six-Day War. The United Nations Security Council, the United Nations General Assembly, the International Committee of the Red Cross, the International Court of Justice and the high contracting parties to the convention have all affirmed that the Fourth Geneva Convention does apply. Numerous UN resolutions have stated that the building and existence of Israeli settlements in the West Bank, East Jerusalem and the Golan Heights are a violation of international law, including UN Security Council resolutions in 1979 and 1980. UN Security Council Resolution 446 refers to the Fourth Geneva Convention as the applicable international legal instrument, and calls upon Israel to desist from transferring its own population into the territories or changing their demographic makeup. The reconvened Conference of the High Contracting Parties to the Geneva Conventions has declared the settlements illegal, as has the primary judicial organ of the UN, the International Court of Justice and the International Committee of the Red Cross. The position of successive Israeli governments is that all authorized settlements are entirely legal and consistent with international law, despite Israel's armistice agreements having all been with high contracting parties. In practice, Israel does not accept that the Fourth Geneva Convention applies de jure, but has stated that on humanitarian issues it will govern itself de facto by its provisions, without specifying which these are. The majority of legal scholars hold the settlements to violate international law, while others have offered dissenting views supporting the Israeli position. Background: shortly after independence, the Israeli Supreme Court ruled that the fundamental principles of international law, accepted as binding by all civilized nations, were to be incorporated in the domestic legal system of Israel. In the aftermath of the 1967 Six-Day War, Israel was in control of the Sinai Peninsula, the Gaza Strip, West Bank, and Golan Heights. Immediately after the war, the Israeli government authorized the construction of military settlements for security purposes. They were built on the fringes of the territories, along the Jordanian and Syrian frontiers and along the edges of the Sinai Peninsula. At the same time, Israel conveyed that it was willing in principle to return most of the newly captured territory. Levi Eshkol offered to return the territories with only minor border modifications. Nevertheless, with government permission granted, Kfar was re-established in September 1967, becoming the first civilian settlement to be built in the West Bank. During the 1970s, Israel's Supreme Court regularly ruled that the establishment of civilian settlements by military commanders was legal on the basis that they formed part of the territorial defense network and were considered temporary measures needed for military and security purposes. After Likud came to power in 1977, seizing land on the basis of the 1907 Hague Regulations, which implied the temporary nature of Israeli presence, was not employed anymore as the new government declared land in the West Bank state land. In 1978 and 1979, the Israeli Supreme Court, prompted by the new government policies, ruled on two important cases that set out the requirements for Israeli settlement legality under international law. In Yair Bayal vs. Minister of Defense, the court determined that the Hague Conventions but not the Geneva Conventions could be applied by Israeli courts on land and settlement issues in the occupied territories. The following year the court ruled on Dwight al. vs. the Government of Israel, outlining the Hague Convention's limitations on Israeli land acquisition and settlements. Settlements, whether on private or public land, could not be considered permanent, nor could the land be permanently confiscated, only temporarily requisitioned. Settlements on private land were legal only if determined to be a military necessity. The original owner retained title to the land and must be paid rental fees for its use. Public lands' possession cannot be alienated, nor its basic character transformed. In 2004, an advisory opinion by the International Court of Justice concluded that Israel had breached its obligations under international law by establishing settlements in the West Bank, including East Jerusalem, and that Israel cannot rely on a right of self-defense or on a state of necessity in order to preclude the wrongfulness of imposing a regime, which is contrary to international law. The court also concluded that the Israeli regime violates the basic human rights of the Palestinians by impeding the liberty of movement of the inhabitants of the occupied Palestinian territory and their exercise of the right to work, to health, to education and to an adequate standard of living. Status of the territories. Although all areas in question were captured by Israel in the 1967 Six-Day War, Israel has treated them in three different ways. East Jerusalem, Jerusalem and its surroundings were envisioned as an international area under United Nations administration in the 1947 partition plan, which was accepted by Israel but rejected by all Arab nations. In 1948, Jordan captured and annexed the eastern half of Jerusalem, while Israel captured and annexed the west. Following the Six-Day War in 1967, Israel annexed the eastern part, together with several villages around it. In 1980, the Israeli Knesset passed the Jerusalem Law stating that Jerusalem, complete and united, is the capital of Israel. The Israeli Golan Heights Law of 1981 applied Israel's laws, jurisdiction and administration in the Golan Heights, captured from Syria in 1967. The public viewed the move as an annexation, but the law itself refrained from using the term officially. The Gaza Strip and West Bank form part of the areas offered by the UN to a prospective Arab state of Palestine in the partition plan, which was rejected by the Arabs. From 1948 until 1967, the Gaza Strip was occupied by Egypt and the West Bank was annexed by Jordan. Together with the annexation of East Jerusalem mentioned above, Jordan's annexation of the West Bank was not recognized internationally. Since 1967, the West Bank has been under military occupation. Gaza was also occupied in 1967, but after Israel's unilateral disengagement in 2005, the status has become disputed, with conflicting opinions on whether or not the occupation has ended. The Jerusalem Law and the Golan Heights Law have both been deemed illegal by the UN Security Council, and are not recognized by the international community. The United States abstained from the vote on Resolution 478 and the U.S. Congress passed the Jerusalem Embassy Act, recognizing Jerusalem as the capital of Israel. The U.S. views that parts of Jerusalem are not in Israel, and the official U.S. position is that the status of Jerusalem must be resolved in negotiations. The EU views that Jerusalem is a corpus separatum, and the United Nations considers Israel's proclamation of Jerusalem as its capital to be null and void. Israel has signed peace treaties with Egypt and Jordan. There are currently no peace treaties governing Israel's borders related to the West Bank, the Gaza Strip, and the Golan Heights. Israel therefore asserts that the armistice lines of 1949 have no other legal status. Palestinians object to this view, as the Israel-Jordan peace treaty was not to alter the status of any territories coming under Israeli control during the hostilities of 1967 of the Israel-Jordan peace treaty. Article 8 of the International Criminal Court Rome Statute defines he transfer, directly or indirectly, by the occupying power of parts of its own civilian population into the territory it occupies, as a war crime. Israel did initially sign the statute, but later declared its intention not to ratify it.